Being in the District of Columbia, which is a very bicycle-friendly city, we get a lot of bicycle crashes. A lot of clients who are involved in bicycle crashes reach out to us, and we've been handling them for years. Whether or not it's somebody driving in a bike lane and somebody makes a turn and infringes upon the bike lane, whether it's somebody who gets doored by another vehicle. In other words, a driver stops and opens his door while the bicyclist is driving with the right-of-way. That actually is against the law in the District of Columbia. You're required to look before you open your door. Or whether or not it's just a case where a bicycle's riding on the roadway and with the right-of-way and a vehicle makes a turn or rear ends them. We get a lot of them. And we've been handling them for many, many years and very successfully.
Really, when you look at the law in DC, what we talk about is vulnerable riders. So it's not just bicyclists, it's also motorcyclists, it's people on e-scooters, even pedestrian. All of them anybody who's not inside a four-wheeled vehicle falls under that kind of category of a vulnerable user. And so the law in that area is consistent across the board. The law now in the District of Columbia is that if you fall into that kind of category, you could be up to 50% at fault and still be able to get a recovery. You can't be more than 50% at fault, but as long as you're 50% or less, you're still eligible to get a recovery. So we do a lot of those cases in getting providing representation for people who are hurt in those categories.
So it's important to reach out to a lawyer that knows what they're talking about, that's going to be aggressive and going to be able to establish that your fault was slight, if any, and that you have a full opportunity to receive compensation for the harms and losses that you suffered.